Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me.
Hello and welcome to a special interview for The Wire. Today we take a close look at how the Supreme Court has treated Ali Khan Mahmudabad. Does it have the power to gag him or has it overreached itself? Should it have questioned whether Section 152 of the Bharatiya Nyaya Sanhita applies rather than simply accept it does and hand the matter to an SIT for further investigation? Should he have been told to surrender his passport when clearly Mahmudabad is not a flight risk? And could the wide-ranging comments by the two judges have prejudiced the case? Those are the issues I shall raise today with the well-known lawyer and widely read Hindustan Times columnist, Gautam Bhatia. Gautam Bhatia, in the op-ed you wrote for the Hindustan Times yesterday about the way the Supreme Court has treated Ali Khan Mahmudabad, you said, and I'm quoting, "It is important to point out that the judiciary does not have the power to gag or silence someone. It's only empowered to determine whether the government's decision to do so is constitutional or unconstitutional." Let me start by asking, how confident are you of this viewpoint?
I think this is a really important question, and it's important to get this straight because of the ease with which the Supreme Court has in recent years been issuing gag orders. Now, I say that the Supreme Court is not empowered to do so because the Constitution does not vest in the court that power. Article 19(1)(a) of the Constitution guarantees the right to free speech to all citizens. Article 19, Clause 2 then sets out the reasonable restrictions that can be imposed upon free speech. And the crucial thing to note is that these reasonable restrictions can only be imposed by the state through law. Now, there is a tradition and a range of judicial opinions that make it clear that for the fundamental rights chapter of the Constitution, the judiciary is neither the state and nor do judicial orders constitute law. And so, therefore, under Article 19, Clause 2, the court is not empowered to restrict free speech. Now, this is not just a question of constitutional text, but there is a very good reason why that is so. And that is that the Constitution is a very carefully crafted document. And given the importance of free speech, which is the lifeblood of any democracy, the Constitution and its creators crafted a very careful two-step process that would result in the restriction of this right. At the first step, the parliament, which is the representative of the people, would deliberate and would pass a law that would set out the circumstances under which speech could be curtailed, like the old IPC, now the BNS. Then at the second stage, if there was an act of restriction under that law, then the court would step in and would review if that restriction or infringement was constitutionally compliant. And so that is the two-step process that the Constitution envisages. That first, Parliament passes a law under which speech can be restricted for certain reasons, and then the court reviews a specific act of restriction or that law itself. Now, what a judicial gag order does, it completely eviscerates that carefully crafted scheme by transforming the court from a review body, which reviews if a restriction on speech is compliant with the Constitution, to a censor. And that is not what the Constitution contemplates, given the importance of free speech, given this careful two-step process that it sets out.
So would I be right in understanding, Gautam Bhatia, that in the absence of a specific law, the Supreme Court doesn't have the power to gag someone's speech? Had that law existed, they could have implemented it or ensured that it was implemented. But in the absence of that law, they can't just gag a speech because they don't like it.
The court has no power regardless. If there is a law, then what will happen is that under that law, the executive will act, and they'll penalize someone or imprison someone or censor someone. That individual could then challenge that act of restriction either by saying, look, this executive action does not comport with the law, therefore it's illegal, or the law itself is unconstitutional. And the court's only task is to say yes or no. That's all. Nothing beyond that.
Doesn't this therefore mean that Justice Surya Kant and Justice Koteshwar Singh have exercised powers that they don't have?
In law, we say that they lack the jurisdiction to do what they've done. And I think it's important to point out, though, that this is not the first time that the court has done this. This has been happening for a few years. And I think it's now become normalized, which is why it's done in such a cavalier fashion. I think also that's why it's important to keep reiterating, as I have at least been doing for quite a few years, that it's not even about whether the court was right or wrong to impose this gag order. It just does not have the jurisdiction under the Constitution to do this in the first place.
And if the court doesn't have the jurisdiction to impose a gag order, then have the two justices acted illegally or unconstitutionally?
No, you can't. I mean, ultimately, just because what the court does is not law. As I said a little while earlier, you can't say that they've acted illegally or unconstitutionally. They have acted outside their jurisdiction. That's what you can say.
But they have clearly acted outside their jurisdiction.
In my reading of the Constitution, they have acted outside their jurisdiction.
And therefore, could someone appeal to a higher bench on these very grounds and say that the justices have acted outside their jurisdiction? They didn't have the power to do what they've done?
You can't do that because it is the court that declares what the law is. What you can do in certain circumstances is ask for a review of a judgment. Now, this is an order, and then, but even that goes before the same bench. So once the court has spoken, the only feasible way to change the court's mind is in the next case to make the argument, or in a subsequent hearing to make the argument and attempt to persuade the court that with all due respect to your authority, this is one area where you don't have the authority to do what you're doing.
And the other thing we can do is to air opinions like yours and make people aware that here the court has overreached itself, that they acted beyond their jurisdiction. That is something else we could do.
Of course, with the utmost of respect for the court.
Tell me, secondly, although Mahmudabad is not found guilty of anything so far, and clearly he would not have been a flight risk. He has, after all, a wife who is said to be 9 months pregnant. He's hardly going to desert her. Despite all of that, he was made to surrender his passport. Isn't that tantamount to punishing him whilst he's still technically innocent?
The Supreme Court has previously held that the right to travel is part of the fundamental right under Article 19, 1D of the Constitution. And so therefore restricting that right, much like in the case of 1918, prima facie, the court shouldn't be in the business of restricting those rights. Now, what the court can do is that if in an order of bail, it finds that the accused person might flee the jurisdiction and therefore frustrate the investigation, then the court can impose restrictions upon their travel. But here there seems to be no indication of that, and clearly that wasn't something that was argued or considered in the hearing. So in that case, it seems to me that this seems more punitive measure than a precautionary measure. But of course, since this is an interim order with very scant reasoning, it is impossible to tell what was in the court's mind when it did this. But it looks like, because there was no analysis, it feels like this seems more. One can't really understand, if he was no flight risk, why this restriction has been placed upon his movement.
Very interestingly, you said this feels like a more punitive order than a precautionary order. Is it another instance of high-handedness on the part of the judges or excessive authority?
I'm sure the judges, believe that what they're doing is right. But this is just what it appears, as I said, because you normally you would have a certain degree of reasoning, behind a certain conclusion. In these interim orders for interim bail, it's often very scant, so you don't really, you don't really see what's going on. But what happens is that in most cases, in most cases, lawyers argue that this person is not a flight risk, is a flight risk. There's a back and forth, and so you can tell why the court is doing what it's doing. The nature of this hearing leaves the question open, because we're not quite sure. Does the court believe that Professor Mahmudabad is a flight risk? If so, why would the court believe that, given his work and so on? Those are all questions that we don't have answers to. So it's hard to tell really what's going on in judges' minds. What we have is the order before us, and we can analyze that based on what we have.
All right, let's go one step further. Let me quote from what Justice Suryakant said in court. He said, and I'm quoting, "Everybody talks of rights. I have the right to do this, I have the right to do that, without telling you what your duty is towards the nation." Now, the Constitution very definitely confers rights on citizens, but are there constitutionally enforceable duties? That's clearly what Justice Suryakant is suggesting. Is he right to do so?
So I think to start with, I just maybe caution a bit that in the heat of the oral argument, often things are said that ultimately are not reflected in the final order. So I wouldn't say that there is a definitive view being expressed by the court. What I will say is that, first of all, of course, you are completely right in that the Constitution does not require or enforce any fundamental duties, for good reason. In fact, the fundamental duties chapter, which is itself not enforceable, is an insertion during the emergency era. And what the Constitution certainly does not say is that the exercise of my rights is dependent upon me performing a duty. We know the really dangerous roots of that argument in history, and I think that's important to keep in mind. I think also what's important to keep in mind is that this is again not something new. This has been remarks of this kind have been falling from the bench for quite a while now, and in fact, I have a clear recollection that a few years ago, Chief Justice Bobde said the same thing. So this seems to be what I've called elsewhere becoming constitutional common sense in a certain way, that the court seems to now believe, or at least that is what seems to come across from these oral observations, that there is some link between performing duties and the kinds of rights you're entitled to. And of course, it's important to keep reiterating once again that that is not the case.
There is something else that Justice Suryakant said that I want to raise with you. This time, it wasn't about Mahmudabad. It was clearly a warning to the students and faculty of Ashoka University. He said, and I'm quoting him, "If they dare to do anything, we will pass an order. It is not acceptable to us that some of these so-called private universities open and then all kinds of elements join hands there and they start making irresponsible statements. We know how to deal with these people." How do you read that? Was this comment at all justified?
So I think the first thing to note is that this comment is not in the final order of the court, so it's not something that is, in the formal record. And so, in that sense, the order, which is the enforceable order, which is the law in a certain sense, does not have this. Now, I think that caveat aside, I think in general there is a very salutary, norm of behavior, which is that if in court someone is not before you, and someone is not in a position to defend themselves or to explain their conduct, it is generally desirable that from the pulpit in the public sphere, that their conduct not be remarked upon specifically in disparaging terms. Now here, the professors and the students of Ashoka were not before the court. They were not given a chance to defend or to explain themselves. And I think in that context, it would have been better, had these disparaging remarks perhaps, remained in the realm of thought and not in the realm of expression, since we are talking about free speech right now.
Let's come to the comments the two judges made about Mahmudabad himself. The two judges accused Mahmudabad of dog whistling, of using words with double meanings, and seeking cheap publicity or popularity. They also questioned what was the need for him to write such posts at this time. And I accept your point that no doubt these were obiter dicta, they were not part of a written judgment. But nonetheless, won't they condition the way the country views Mahmudabad's posts hereafter? And more importantly, won't they influence the SIT that's been appointed to examine these posts? In other words, was it right for the two judges to have spoken in this way, knowing that it can have an influence which they may not have intended, but it would be equally undeniable?
I think in legal and in doctrinal terms, these observations, since they're not in the record, don't have any legal force. And in an ideal world, they would not influence either the SIT or the judge before whom the case is. So they're not meant to. And often you will find that, in fact, for example, when a court is giving a bail order, they of course have to examine the facts to a certain degree, but then they make clear that these observations will not impact the trial court in its judgment. So formally, and if every officer involved here were to act in the way that you would expect them to, these observations would not have an impact. But of course, we know that words have power, and specifically words that come from an institution wielding the high authority that a Supreme Court does. Words have a lot of power, and I think that in that context, again, it would generally, one would generally hope that that is something that the court as an institution would be aware of when it were to express itself in oral argument. And I think that there are two kinds of things that happen in oral argument, as anyone who's been in court knows. One is that the court, to test the strength of someone's case, puts questions that could be adversarial, could be hostile, and may not reflect the court's views. To someone who's watching, it may sound as if the court has made up its mind, or if the court is, expressing itself in a possibly intemperate way. But those are observations meant to test someone's case. But they are also distinct from a situation where the court expresses what seems to be its opinion about the case. And I think that if and when it is the latter, then there it becomes important that the court be aware of the power that its words carry, and that awareness inform the way it expresses itself.
So would I be right in saying that the two judges were careless in their comments and they should have been more cautious in their speech?
That is not something I would express an opinion on. That is something that the viewers, I think, would make up their own minds on. What I will say is that when you say that Professor Mahmudabad was guilty of, or not guilty, but when the court says that it appears that Professor Mahmudabad was engaging in dog whistling, I think that it's important to unpack that a little bit, because dog whistling is a very specific term. It has a specific meaning, and it refers to a situation where, as in a dog whistle, where the dog whistle's frequency is such that human beings can't hear it. Dogs can. Similarly, a dog whistle is a remark that you make, which your constituency would understand as, and normally understand as, calling for violence or calling for disorder, whereas the larger public would not see it that way. What in Hindi we say, ishara, samajhdar ko ishara kafi hai, right? So it's that phrase. And so then if you're saying someone is dog whistling, and if you're saying it as the Supreme Court, it's important to then clarify where the whistle is in that Facebook post, who the dogs are that it's addressed to, and who the non-dogs are that wouldn't get it. But we don't have any of that. It's a word that is dropped into the conversation without further explanation. And similarly about double meaning. So if the court is saying, even in oral observation, that these words have a double meaning, then I think that given the authority that the court wields, we should be expected we are entitled to expect that the court then at least indicates which words have the double meaning and what the double meaning is. And in the absence of that, then it becomes difficult again to parse what the court is thinking and what is informing the court's final order.
And I'll just point out, for the sake of the audience, that none of that happened. Neither did they clarify what was the dog whistle, nor did they clarify what were the words that had double meaning. They simply left those hanging in the air. But let me go a little deeper. Should the Supreme Court not have asked itself whether Mahmudabad's post justified charging him with Section 152 of the Bharatiya Nyaya Sanhita, which is, I'll add for the audience, the new version of the old sedition clause? As far as I can tell, the court simply accepted that it applies without questioning whether it does.
I would slightly modify that. The court did not accept the replies. The court delegated that task to an SIT. Now I'll explain that in a moment. Now the prayer or the plea made by Professor Mahmudabad's lawyers and counsel was a stay of the FIR against him. Now, it is obviously a high burden to ask the Supreme Court to stay an FIR at such an early stage. And so the question that then the court has to address in that situation is that, okay, here's the text of 152 BNS and here's what it requires. Here is the Facebook post, which is the subject of the FIR. If I were to read the Facebook post, in its worst possible light, in its worst meaning that I could give it, would it, on a prima facie reading, meet the criteria of the BNS? And if it appears to the court that under no circumstances would that happen, then the court has to stay the FIR. So it does require the court to engage in some kind of an analysis of the offense and the offense's ingredients and the offending speech. Not a deep analysis, but some analysis. Now that does not happen in this order. In fact, what the court does is that it says there is an SIT of 3 police officers which will be constituted, and that SIT will determine the intent and the holistic meaning of this Facebook post. Now, to me, that comes across as quite odd, because it is actually the court whose task it is to, in free speech cases, to ask itself that does the meaning of this speech constitute an offense under existing law? That is quintessentially the court's task. I'm not quite clear on why the court has delegated that task to 3 police officers, in this case.
And in addition, if the court is of the belief that that Facebook post has been worded cleverly with double meanings, then it's up to the SIT to decide which of the 2 meanings or 3 meanings are to be the ones that the author actually intended. And will the SIT have the expertise to do so? They need to be lexicographers, perhaps.
I think that again, we don't really know, because the remit of the SIT has been left quite vague in the order. It says that holistic meaning of what was said. So will the SIT perhaps lay out all the 2, 3, 4, 5 meanings of that post, and then will the court take a call on which of these is the intended meaning, or will the SIT pick one meaning? Like you said, I think we are getting into the domain of literary critics here and literary scholars. And so to me, it remains quite unclear what the SIT will do and how they will do it. I think, but I will point out that one important thing to note is that as far as from what I've read, Professor Mahmudabad's laptop has been confiscated. And I think that one thing we should all be clear about is that insofar as the SIT has been appointed to interpret or to figure out the meaning of this Facebook post, that should not become a ground for what in law is called a roving and fishing expedition, where then the contents of Professor Mahmudabad's laptop then are, in a certain sense, are opened up for investigation, because then you have the right to privacy and all of that come into play. So I think that it's important to again reiterate that if the SIT's constitution is to investigate the Facebook post, then it should be limited to doing that and to its conclusions on that Facebook post.
Let me ask you one more related question. Do we as citizens have a duty to be patriotic? Can't we be skeptical and questioning rather than patriotic without incurring Section 152? After all, I'm always reminded that Samuel Johnson very aptly said, patriotism is the last refuge of the scoundrel.
And Samuel Johnson was saying that in the context of trying to distinguish between what he thought were the true patriots and those who were using patriotism as a shield to commit misdeeds. I think which only goes to show you that right from the establishment of the Westphalian nation state 500 years ago, the question of what constitutes patriotism and who is a patriot has been deeply contested. And that is why, for very good reason, the Constitution does not compel patriotic speech. Patriotism is not a ground for the restriction of speech under the Constitution. and the BNS, which is, of course, a progeny of the old sedition law. Now, the BNS is, the words are a little wider, but if you look at the old sedition law, it's interesting because the sedition law which used to exist was the old British law, and its words were, whosoever excites contempt against the government or attempts to bring it into disaffection, is subject to that hatred or contempt is subject to the law. So actually, the old sedition clause was worded somewhat similarly to coming close to requiring patriotic speech because it penalized spreading disaffection against the government. And in a very famous case called Kedarnath Singh in 1962, the Supreme Court, in order to not strike down the law, read it down substantially and said that only that kind of speech that has, a tendency, or now the new test is the incitement. So that kind of speech that incites public disorder is the only kind of speech you can restrict consistent with Article 19, Clause 1A and Subclause 2. So to answer your question, in brief terms, the answer is no. The Constitution does not require patriotic speech, and the Constitution does not punish what some might call unpatriotic speech. And I think, again, history is really a good guide here, because whenever governments have attempted to enforce patriotism by using coercive measures, it is just, it's just not worked. And much like love, patriotism is something you can't compel. You can't force it. You can't legislate patriotism into existence. And as you know, there's this famous story that in 1933, with World War II just over the horizon, the Oxford Union, which is the Oxford University's debating society, had actually initiated a motion called "This House will under no circumstances fight for its king or country." They had a full debate over it, a very fiery debate, and then they passed the motion. And Winston Churchill was livid, and he gave a speech saying that I see all these German soldiers marching in step, and then I see these resolute university students. And Churchill's son, Randolph Churchill, tried to actually strike off that motion from the register. And what they did, they basically threw eggs at him all down Oxford streets. And then, of course, that did not, Britain did not break apart. Britain did not dissolve. In fact, Britain won the World War. So I think that, again, I mean, history shows that if you respond to, and of course this is not even a case of that, but if you respond to people who are in certain ways alienated from the nation state by coming down on them with coercive law, then that is not going to solve any problems. And I think that that's a history lesson that we do well to keep in mind.
And let me add, for the sake of the audience, that many of those young Oxford students who voted against fighting for king and country actually ended up laying down their lives in World War II. That's an important thing to remember, because that was not necessarily a defining moment in their lives for them. It was simply what they chose to say and what they believed in at that time. But before I end, let me briefly broaden our discussion. There is a view, Gautam Bhatia, that given the circumstances prevailing today, the judges in the Mahmudabad case were genuflecting to the political gallery, and in their spoken comments, they were more concerned about conveying a political impression about themselves rather than about the rights of Mahmudabad or their own beholden duty as guarantors of our constitutional freedoms. How do you respond to that view?
I disagree with that, because I think that the Supreme Court over the last at least decade or so has been fairly consistent in its approach towards free speech. And its approach towards free speech institutionally has been one that is the approach of a disciplinarian in a certain sense, where it seeks to discipline what it sees as disorderly or otherwise undesirable speech. This is something that you see common across judges, with a few exceptions. And I think we could say that it has been an institutional philosophy of the court, which is, let's just say, it's a certain conservative judicial approach towards free speech. And I think that if you look at that in context, this is perfectly in keeping with this historically conservative approach towards free speech that the court has exhibited over the last few years or so.
So, in other words, the Supreme Court was behaving like a disciplinarian nanny rather than passing subtle messages to the ruling party of the day.
No, I wouldn't say that. I would say the Supreme Court has a philosophy or a judicial philosophy that is conservative towards free speech and that looks at what it thinks as disorderly speech with a degree of annoyance or considers that to be a bit of a nuisance that requires to be disciplined. So I think that it's important not to, and I think this is a problem we often see in the US, where there is a fixation with the individual judge instead of really analyzing the court as an institution with a certain institutional philosophy. And my attempt's always been to do it that way and to ask the question that what does a particular hearing tell us about the court as an institution and its judicial approach towards issues, because it's not about the person or a person's views, but the way the court understands constitutional issues and acts upon them. That's more important.
My last question. We're very conscious as a country of politicians abusing their power. We're very conscious of bureaucrats abusing their authority. Is this not a case of Supreme Court judges abusing their position and the law which gives them power? Or am I putting it too strongly?
I think the question of abuse is quite subjective. As I said, for me, the point of critique is that the Supreme Court in this order is acting outside jurisdiction. Abuse gets us into questions of intent and so on, which I don't think we're in a position to definitively answer. So I think that it is about.
Can I interrupt? Could it be possible that they accidentally went out and acted beyond their jurisdiction? Surely your jurisdiction is something judges should be crystal clear about. You don't accidentally trespass it. You only do it.
I think there is a disagreement, over what constitutes the court's jurisdiction. So obviously, when a court passes an order, the court genuinely believes that it is acting within jurisdiction. This is simply a disagreement about whether or not that is correct or not. Just as we disagree with the substance of judgments, we disagree with the merits of cases. We disagree with the court on whether it has jurisdiction or not. It's just an example of that's going on.
Okay, Gautam Bhatia, thank you very much for your analysis. Thank you very much for making time for me and explaining things so cogently. Take care. Stay safe.
Thank you.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch The Interview. Your viewership means an awful lot to me.